Good morning, and I'd like to welcome everyone to the 10th meeting of the Standards, Procedure and Public Appointments Committee in 2025. I've received apologies this morning from Ruth Maguire, and so can I welcome Rona Mackay, who's attending as committee substitute, and I've also received apologies from Annie Wells, MSP. Our first agenda item is for the committee to decide to take items 4 and 6 in private. These items will be discussing the evidence that we're going to hear over today. Are members content to take that in private? I'm grateful. And we come to agenda item 2, where we continue our consideration of the Scottish Parliament recall and removal of members' bill at stage 1. Can I welcome the Minister for Parliamentary Business, Jamie Hepburn, MSP, and his supporting officials, who today are Leila Brosnan, Shadow Bill Team Leader, Ailsa Kemp, Parliament Legislation Unit Team Leader, and Jordan McGorry from the Solicitors Department. I'd also like to welcome Graeme Simpson, MSP, the member who's in charge of the bill. Minister, can I invite you to make some opening comments?
Certainly, thank you. First of all, thank you very much for inviting me to give evidence today. I'd also like to thank Graeme Simpson, who I see is with us today, very eager and keen for the open and constructive discussions that we've been able to have in relation to this bill. First of all, as he's developed his proposals, and now that the bill is before us. Convener, in terms of the broad intention of the bill, the Scottish Government supports that in its aim to uphold standards and improve the democratic accountability of members of this Parliament. The people of Scotland need to have confidence that their elected representatives are held to the highest standards of behaviour, and that there are robust systems in place to deal with any member who does not uphold those standards. I recognise, of course, that it is for Parliament to determine the standards regime for its members, not for Government, and similarly it's not for Government but Parliament to decide whether to sanction its members using recall and removal procedures. We are all aware, and I'm very pleased that the corporate body is now initiating an independent review of the complaints process, which may see the consideration and delivery of sanctions changed to deal with any concerns around, or perceived concerns around, the independence and impartiality of the process in future. While matters within the Parliament, as I say, are ultimately for Parliament, I think there are a number of principles upon which we can all agree. I believe we're all committed to ensuring any procedures that are introduced are fair, are transparent, efficient and effective for those of us elected to this place, for MSPs, for those who operate the system, I think, above all and most importantly, for members of the public, those who we are elected to represent and to serve. I hope that the procedures set out in this bill, if it's passed and becomes an act, will stand as an additional incentive to both current and future MSPs to maintain the highest standards. It should go without saying, but I'll say anyway, Convener, and I'm sure again we would all feel this. I would hope that rare would be the occasion, indeed never would be the occasion, that the processes were used. But if they were to be, we need to make sure that those processes work smoothly and are sufficiently clear to command public confidence. We have an electoral system for this Parliament that is different from any other UK legislature. Of course, that means we have to have a recall system that works for Scotland and its Parliament. We are not the Westminster Parliament. We are not the Welsh Senate. We can certainly learn from both of those institutions, one of which we know already has a recall system, and the other which is doing, as we are, presently considering and working on its own recall legislation. But we should take this opportunity, if we're taking forward these proposals, to develop a system that works for Scotland, for this Parliament and for the people who elect our MSPs. And I'm very happy to hear from the committee today, and along with Leila, Ailsa, and Jordan, very happy to answer any of your questions.
I'm very grateful for that, Minister, and I sincerely hope all elected individuals will echo much of what you said about the importance of transparency and the importance of being properly held to account. So we will hold to account, and I will pass you over to Emma, who has the first set of questions. Thank you, Emma.
Thank you, Convener. First of all, Minister, I'm interested in, you say the Scottish Government supports the principle of a recall mechanism. Could you expand on why exactly that is?
Well, I suppose the first thing I would say is that, it's an in-principle support, and it's for the reasons I've laid out in terms of enhancing confidence in the process we have to ensure that members are held to the highest standard of behaviour, and if that's felt not to be the case, then the ultimate arbiter are members of the public. I think that's a principle that is worth having, and indeed we'll recall in the 29th of May last year, we had a vote in this place where ministers voted in favour of the concept, the principle of a recall system. Of course, the devil's in the details, so we're moving from principle to the practical considerations of what that would look like. So, yes, we support the principle, and we now, along with Parliament, have to consider the specific details.
So it is primarily that improving of the accountability between elected representatives and the people that we serve, and being able to hold individuals to account for their conduct. That's the primary aim.
That's right. So, clearly we have a system now where the arbiter is Parliament itself. By and large, it might be felt that's a process that's served us for a long time, and more often not has served us well. But if we are accountable to the public in the sense of being elected here in the first place, then I think certainly the principle that we should ultimately be accountable if we're introducing a system of further deliberation around the standards of people in here, then that should be in the hands of the public as well.
Yeah, absolutely, I agree. There are, of course, other principles at play that might conflict with what we're trying to do here with a recall mechanism. One example being the proportionality that the Parliament and the voting system that we have in Scotland set up. The committee has heard from witnesses that some do wish for other aims to be pursued through this legislation, as well as that accountability part. So do you think that it's worth exploring those other issues, like rerunning the election in a particular seat or region to reflect the voters' feelings at that time, not just towards the individual with the conduct issues, but the parties as a whole? Or should we be protecting those principles and focusing mainly on conduct and accountability?
Well, ultimately the whole process is triggered by issues around conduct, so that has to be our starting premise. In relation to the issue of proportionality, well, as an aside, there's two issues around proportionality. There's the issue of, have to consider whether a system of recall itself is proportionate to the trigger mechanism. Mr Simpson's obviously laid out what that might be, and it's for Parliament to consider if that's proportional. But I think, if I picked up correctly, that's not the issue of proportionality you're referring to. Could this have the effect that will alter the proportionality as determined at a general election? Yes, it could. Of course, our system already, to an extent, it has that built in through the process of by-election. We've just been through a by-election, and I won't linger too long on the outcome of the by-election, but that has changed the nature of numbers by comparison to the general election we had in 2021. So it is already part of our system. I accept that this adds. I'm trying to think of the word. Complication was the word that came to mind. Complication is not the right word, but this does add another layer to the issues around that which might affect proportionality, but it is already part of our facet of our electoral system already.
Thank you.
Just to pursue that point a little further, if we take the sad cause of the recent by-election having to take place, that was on the basis of a first past the post that we have in Scotland. The proportionality on the regional list, although the effect would percentage-wise be the same, we're talking about one member being replaced. What is the Scottish Government's view about the risk, the inherent risk of instability through that, if, and as we've heard some witnesses have given evidence to suggest that actually the process of replacing the member may become more a comment on the government, on parties, on other events, rather than, I think, what the Scottish Government, and certainly a lot of evidence we've heard, it should all be focused on the conduct occasioned by the individual that has led that. Does the Scottish Government have any concerns about, in essence, the question shifting from an individual MSP, dependent on how they vote? I think it's relatively straightforward in a constituency because that's the individual who was elected. But in the regional, where it's a party vote, are there concerns the government have about that affecting the proportionality?
Well, I think we'd all be naive to suggest that politics isn't going to come into the process. That's the nature of the process that we participate in. And this could only ultimately put to the test if we institute such a system, and then we have to go through, unfortunately, the process of recall, which again I would set out, and I think we all agreed we would hope did not happen. But if we consider those that have taken place, I mean, we've only one experience of it in Scotland in terms of the Westminster system, and my experience of that was actually through the process of consideration of recall, that people were focusing on the conduct of the individual member. And, you know, I'm struggling to think why that would, by necessity, be any different if it's a regional member by contrast to a constituency representative. But ultimately, we would only know if we had to go through the experience, I suppose.
Sue, may I pass to you?
Thank you, Minister. Good morning. In the Scottish Government's memorandum, you mention, or there's mention of the legislation being future-proofing, and I was just wondering if you could say a little bit more about that and what your thought process was in terms of what that might be. Or...
So that was with particular reference to one area, and it's largely predicated on the experience we're going through right now. So Parliament instructed the corporate body to go away and look at the process we have for sanctioning an individual MSP. So what that was alluding to the fact that we need to be careful that we don't prescribe a specific process on the face of this bill. Or certainly this is our perspective. I think it's what we were doing through that memorandum, of course, was just offering prompts for the committee to consider. So I'm just speaking to that. But what the committee and Parliament would have to consider is whether or not we should be overly prescriptive on the face of this bill about a process, or recognise that, for instance, the corporate body right now is looking at the potential for a change to the process, may make recommendations, and then we'd want to have the ability for that to be reflected in any process of recall that was instituted. Now, I only proffer the corporate body example because it's one we're going through right now, but inevitably standing orders or processes change and develop and adapt all the time. So it's really just to reflect that. That's the only thing that's a reference to.
Well, that's fair, because the pace of change of the world is galloping ahead in so many different ways, so we need to be able to shift the dial. You've already mentioned that politics will come into the process, or will likely, I think you said will. In relation to the parliamentary sanctions and the grounds for recall, we have heard that is likely to have the potential to be politicised. So I was wondering if you could speak a little bit more about that, because we have heard that it might even come to the fact that a political party may take a view on a candidate that perhaps isn't, I'll use the word towing the line or the party line, and then it may be a target for, maybe beneficial for the party to try and encourage something to happen to that particular MSP. We are in a world where, I'm being a bit cynical, but I can understand that you know where I'm going with this line of questioning. So how can we protect from that as well, but at the same time make sure that the process allows that recall to commence in a very stable, sensible manner, rather than it being a knee-jerk political way?
Well, I'm an optimist rather than a cynical person. I'm sure everyone would agree from their experience of interacting with me. I do genuinely struggle to see the circumstance, although you're right, Ms Webber, to caution and suggest there's a potential for us that a political party would encourage the disbarment and the removal of one of their own members for wider reasons of perception. But you never know. I suppose it's a possibility. I think the wider point really is how we can try and ensure that there is minimal politicisation at the appropriate part of the process. And I think that speaks to the mechanism that would trigger the recall mechanism.
Do that, to minimise the politicisation.
So I suppose that goes back to one of the things that Parliament has, and I'm going back to the point I just made, Parliament has asked the corporate body to undertake a piece of work to make recommendations. I think largely that was the question that was predicated on. So we await to see what they might recommend. So there's that element of it. When it gets to the actual process of a recall petition, I think it becomes much harder to do that, and I think we should just be realistic enough to recognise that.
Yeah. Okay, thanks. Organisations have spoken, that we've spoken to, feel that having lay members involved in the considering of complaints against MSPs could be beneficial. Do you think there's a place for lay members in considering complaints against MSPs and possible sanctions?
So I should say the government doesn't have a specific perspective on that, but I certainly think it's an intriguing proposition, and if the committee is inclined, it's not for me to tell the committee what to do, but if the committee is inclined to explore it further, then I certainly think it would be interesting to have a wider discussion around that. The government doesn't have a perspective on it, but beyond my observation, I think it's certainly worthy of consideration.
Okay, thanks.
Did you want to come in?
Yeah, just on that point around who's dealing with the complaints and how wide a group that is, particularly given we may be considering some very personal issues. Does the government have concerns about personal information being protected, potentially politically sensitive information about individuals? And how do you see the comparison to other issues where it's the presiding officer that would deal with such complaints?
I think I'm probably more, and we're talking about the recall mechanism more here. I think that might come into play more in the other part of the bill that relates to the attendance requirement. I think would probably be more where I think that would need to be given further consideration, because ultimately, the way I've read Mr Simpson's bill, he'll be coming to give evidence to you, so he'll explain it, his rationale for it, but a person, an MSP, would be able to give reasons as to why they weren't able to attend, and if they were legitimate reasons, then that would be enabled, but it would immediately raise the question of, well, what are those reasons? And if a person feels that they are a private matter, and there is still an extent to which we are, despite being elected and in the public eye, we are still entitled to a level of privacy in terms of our own personal lives, but inevitably people will ask or speculate as to what those reasons it might be. In terms of the process of recall, I think it's an interesting question, but I struggle to see the circumstances in which those personal matters would outweigh the reason for the recall process having been triggered in the first place. It might be possible to build that into the system, but that would be something that the committee would have to consider.
I suppose when you look at situations that have occurred in the Parliament so far, where a recall could be triggered under the proposals, there have been particularly sensitive issues, and I guess the moment it gets out there into a wider debate, it becomes very difficult to be reasonable.
Yeah, well, yeah, I appreciate that. I'm going to avoid commenting on specific cases because I think that just takes us into into territory that we're probably, of course, it's going to inform our considerations. We shouldn't be naive enough to pretend it won't, but there's a proposition here that we have to consider without reference to specific cases. So yes, it is possible, I suppose, but I struggle to see how the process itself could take account of that.
Okay.
There might be a way, might be a means, but we'll see if that can be devised.
Thank you. If I just pick into a little part about what should and shouldn't be in the legislation and the suggestion that the legislation be iterative, with regard to the actual process, the government are content for that absolutely to sit in primary legislation. The suggestion from the memorandum is that there's provision to extend the occasions when it may be triggered and to leave the opportunity open for that to appear presumably through secondary legislation. Is that right?
Well, I think this goes back to, if I'm picking up the question correctly, Convener, this kind of goes into the future-proofing area. So, whether or not it's done by secondary legislation or whether there's reference to standing orders, which, of course, the development of which themselves are an iterative process. Presumably right now, the process we have, again, we shouldn't second-guess what the corporate body might recommend. Their process is underway. That's welcome. I suppose it's theoretically possible the recommendation might come forth that there's no need for change, but our process right now would mean that we need to consider a change to our standing orders. So could the bill, for example, and again I will proffer these as suggestions to be explored, the government doesn't have a specific perspective on these, but could the bill include a reference to our standing orders, or alternatively could these things be done through secondary legislation? That's a question I think the committee needs to grapple with. So I think both are possible.
So, absolutely. So, if I get this right, the Scottish Government is suggesting, rather than saying this is their view, but are you content for, in essence, a bill to try and hypothesise on unknown unknowns in the future?
That's an unknown unknown.
Okay, I'll take I'll move on to one of the challenges that I think we've heard a lot in this, which is the parity between the route into being elected regionally and the route to being elected as a constituency MSP. And where the basis which Graham Simpson has spoken about right from the outset of the consideration of this bill is that there should be parity across all MSPs, because when we come into this place and take our seat in the chamber, irrespective of how we arrived there, we have parity. What is the Scottish Government's view on whether that parity is, as an MSP, when you're sitting in the chamber, we are all the same? Or is it actually also with how the journey we took to get here, so on the regional list or the constituency list? Or is there a space in there where we can say, absolutely there's parity in the chamber, but for the purposes of how we travel in, there isn't parity, which there isn't?
It's a good question, and it's one that I think might be the most difficult one to grapple with as we take this forward. It reflects the point I made at the outset. We have certainly on these islands a unique electoral system for this place. No one else uses the additional member system or the D'Hondt formula in terms of the allocation of regional MSPs. So it is one we have to grapple with. I think our starting premise, the starting principle must be, once a person is elected here, we do have parity. There is, how you were elected shouldn't really make any difference in terms of the rights, the privileges you have, the esteem in which that you are held, at least through process of being elected here. But yes, it's possible that the process could recognise the fact that we have been elected through different processes, because that is a matter of fact, as you have set out, Convener. So it's just trying to get the balance right, because for the system to be viewed to be fair, I think as much as we possibly can do, there should be parity, but that is balanced against the reality that we are elected in different ways.
But the parity would go further than that, in the sense that there would be parity until the triggering of the event that would lead to recall petition. So actually the parity commences when you take your oath, and actually through, if proved and through appeals shown that you're considered unfit to hold this office, there would be parity all the way through to the point. Are the Scottish Government comfortable with that being the edge of the parity, and actually the process of recall or how it goes about could differ to absolutely reflect the different way someone came into here prior to taking their oath?
We haven't taken a specific view on that, convener. I mean, I suppose fundamentally the issue we're grappling with is, as proposed, and I don't think you could do anything other than enable a person who's been elected to represent a constituency the ability to stand in any subsequent by-election if they are recalled. But clearly there is no process of by-election for the region now. Mr Simpson has proffered a solution earnestly and in good faith, I believe. The question is whether or not that is something that ultimately should be reflected in the system. I think that's something for Parliament to grapple with. The Government does not have a view on it.
Yeah, so the Scottish Government not having a view on it, would that also extend, we'll get to the unknown unknowns, would that also extend to views or opinions that come out through our Stage 1 report here, that there could be changes? Not only does the Government not have a view, is the Government in any way concerned that there might be a different journey for different MSPs after the recall has been triggered?
At this stage, no. But we will reflect on your report, and I'm sure that will be informed by the evidence you gather. Absolutely.
One of the interesting... Oh, sorry, Emma, did you want to...
After this.
Okay. Well, I was going to move on to some other little bits. So,
you said there, Minister, that a constituency member who's been recalled would have to be allowed to stand in the by-election. Why is that, if not doing so would create parity with regional members?
Now, I should say I'm not a legal expert, but I think probably CHR issues would come into play. And the question might be, is that also something that would have to be a factor in determining the element that relates to the regions as well? I think what I'm doing today is just offering areas that I think the committee might have to consider. So I think that would be one. Certainly, even if I'm incorrect and they wouldn't have to be allowed the opportunity. Certainly the bill, as if I've read it correctly, as proposed, would provide them that opportunity. So as drafted, there is that opportunity.
One other issue that we've had around this with witnesses is the current setup of the list allows a party to skip names, and in the situation where there's a conduct issue that's resulted in a recall, they might be quite tempted to skip that name, but the bill currently might not allow that to happen if the regional member won the ballot to return. Does the Government have any views on that?
No.
No.
If we look at the journey of certain elements after this, and particularly the first one I want to take is, what's the Government's view on the fact that the petition, if you walk through that door, everyone knows what your indication and position is? Do the Government have concerns about the fact that there is no anonymity in that decision, whereas obviously there is anonymity when you step into the polling booth itself?
I think it's a good question. The right to secrecy is something we tend to try and avoid generally, but except for insofar as the principle of a secret ballot, a person to be able to go in and cast their vote without anyone else knowing how they've cast their vote is an important part of our electoral system. Clearly, the process that exists right now for Westminster recall. That isn't really enabled if someone comes in to sign a petition as devised. That would, I think, if I read it correctly, be the case with this bill as well. So it's something I think the committee has to consider. I think I've seen some evidence proffered, and I know the Electoral Commission's already made recommendations in the context, I think, of the Westminster system around, for example, should a person be able to go and sign the petition effect saying, no, I don't agree, this person should be recalled. Now that then raises other questions about how do you factor that in. Does that mean there has to be some balance between those who said, yes, this person should be recalled, and no, the person shouldn't be in terms of threshold? But it would, at least, I suppose, have the virtue of people being able to go in and take part on the basis of without people knowing precisely how they've responded to the petition. So but I should, of course, caveat that with St Kilda, we've not taken a specific view on that.
You avail me the need of asking my follow-up question on that point. So does the Scottish Government have a view in respect of the percentages that will occasion the recall? So a constituency MSP, in order to be recalled, the figure that's being proposed is 10%. However, in a regional position, not only is it 10% overall, it has to be 10% in 3 areas within that. What is...
Again, we don't have an opinion per se, but what we did flag in the memorandum was that I think it would be useful to explore and understand why that's the case. Now, I think we can understand quite obviously, and there could be a justification on the basis of the manner in which a regional MSP is elected, is calculated and predicated on the number of constituency seats that their party, if they're standing as a party candidate. Of course, we have in the past had independent member elected through the regional system, but putting that to one side for a minute, in terms of most of us elected this place on a party ticket, then the constituencies come into play. I suppose what we were merely observing is equally you can still have subdivisions of a constituency as well. So I'm a constituency representative, and there are multiple polling districts, for example. So, I guess the question would be, why isn't it that there should be X number of polling districts, for example, that this threshold has to be reached? We don't have a view in it. It was really just more to suggest or open up as a question the committee might like to explore.
Although the Scottish Government don't have a view on it, there is clearly, in raising the questions as you do at the constituency level about polling districts, a level of concern that there appears to be a disparity in the level that's needed to be achieved for one MSP as compared to another. Is that a fair representation of the government's position?
Yeah, I suppose, again, it's really positing it as a question you might like to explore, and I think I've gone into the sort of specifics of it, but yes, that is fundamentally the question. Why is it? And we're talking about parity, why would it be that one MSP, because they are elected to represent a constituency, there is no subdivision requirement, whereas there is for a regional MSP? No.
But the government do not have any overt concern on where perhaps indeed this committee lands with its stage 1, or indeed what comes further down the line, other than the unknown unknowns.
So we'll need to reflect on what is recommended. It's merely an observation that there is, and I think I can fairly say, and I have laid out, in terms of the fundamental question, I think parity of esteem for those of us elected here is an important principle, but also parity of process, as much as we can possibly achieve, is an important one as well. So it's really just an open question.
But I am right in clarifying that there isn't a concern if there was a different journey for one group of MSPs, depending on how you came here, as to how you leave compared to the other. At the current moment, the government have no concerns if there is that difference.
We have no opinion at this stage.
Touché. There is the question of the petition process itself. where in essence we have an individual whose name will appear and whether there is a yes or a no, depending on who goes in and how they sign. But the reality is there will be an individual who is hoping that their electorate don't reach that 10% and may well indeed campaign in relation to that. The flip side of that petition is there is no party political campaign could take place. It could be a group of invisible unknown on social media with letters sent to constituents anonymously. Now, the government will have to take a decision on the financial instruments and that. So what is the government's concern about, in essence, an unknown campaign spending millions and millions of pounds to oust an MSP? Does it have any concerns?
I think that would be an area of concern. I suppose it goes back to the fundamental position that there should be transparency generally in terms of campaign finance. We just passed an elections bill, now the Elections Act, some of which we'll go on to discuss in the next session, that touched on areas of campaign finance, and I was fairly clear at that time that the fundamental issue there is transparency, but there are also issues around limits and expenditure, because that then becomes a question of fairness. So whilst we don't have necessarily a specific view on what those that might constitute in terms of the specifics, I think I can safely say that would be an area of general concern just now.
But the reality is, in a petition situation, unidentified groups who don't register and may potentially, subject to legislation, if you can identify them, fall foul of something. But what do we do about that? Because there are legitimate examples. I mean, I think back to the Isle of Jersey, where they have effectively a none-of-the-above option, where there's only one candidate. And in the last election there was a very orchestrated anonymous campaign to ensure that none of the above won. But you couldn't identify who was funding it. You couldn't identify where the correspondence and the social media posts were coming from. And clearly it was successful in that first round. There were changes because obviously there was a re-election in that point. So concerns, work that's been done, thought that's been given as to how we would deal with that matter here.
So that's again, we'd need to look at it in terms of, first of all, this bill advances and consider how we might deal with it. I suppose the point I would make is those are areas I think I can safely say the government would be concerned about. We should have a line of transparency in terms of how much is being spent, who's spending it, and where that money and expenditure is being derived from. I think these are important parts of our democratic system, and I think we recognise that is important in terms of people being elected to this place, or indeed other parts of our democratic system. We recognise it's important there. I think we should also recognise it as being important in terms of any recall process too.
Do you see this bill as the vehicle to do that in?
It might be. One of the challenges we face, and it's probably less of an issue here, although we'd need to explore it further, but you know, it's a recall mechanism is probably a fairly clear and distinct process, but again, it would need to be something to consider. But there is, in the instance of elections here, if there's an election, a general election for the UK Parliament in the same regulated period, then expenditure in both those elections starts to interact with one another. So, you know, the question
Absolutely.
is, what if there's a recall petition within that
Sitting
period
on top of
too?
it. Well,
so
these why I asked the question of the government.
Yeah, so these are things we'd need to consider.
Can I leave it that perhaps that consideration, even if it is just at a top level, is relatively soon, simply because of the 6-month limit? You know, there are questions about, we have an election next year, the various recommendations, because I think potentially it is an area where absolutely, and I'm glad that the government, you know, agree that it sits within one of the areas that absolutely rests with them that happens, because I think there are questions But I'll let you come back, Minister. But there are questions, particularly about the petition, which may be an electoral event, but is not an election, and how that is dealt with. You wanted to.
So it doesn't entirely rest with us, of course, because in terms of the regulated period for UK elections, we don't control the law around that, and this is where it becomes difficult, because the interaction of expenditure and elections here then interacts with that part which we don't control, and I suppose if you start to throw this into the mix, it's something we'd have to consider further.
Expenditure on a petition may or may not be an election expense, irrespective of when it happens. If it is and falls within certain periods, it will cause problems. And I am inviting the Scottish Government to consider that in a bit more detail, because it potentially ties into whether or not a petition is the right vehicle to do that first part if it becomes an uncontrollable event.
No, of course we will have to consider that. I suppose the point I'm just really making to the committee is, in considering it, there are still going to be limits to what we might be able to do at the other end.
I appreciate that, and you're not the only body that sits in respect of that. My final question really is just about voter education and the fact, does the Scottish Government accept that, as we've already heard, we have a different election process for the Scottish Parliament that is different to anywhere else in the UK, that's separate to any other electoral event that happens here in Scotland, and that what we're talking about is adding another event into that, and that the electorate will, need to understand what they're being asked, how they're being asked. How far is the Scottish Government responsible? I recognise the Electoral Commission and others will have a sort of teaching role in it, but there will be a cost to this. What is the Scottish Government's view on that?
Well, there'll be a cost to all of this. I mean, the presiding officer already indicated that a financial memorandum would be required if this was to proceed into law. So yes, there'll be costs throughout, and if there's going to be a education campaign, for want of a better term, then that would be a cost. That would be something we have to consider. I mean, I would observe that you've made the point that the additional member system is a facet of our electoral system here. That was new in 1999. I think people are largely used to that now and understand that they've got two ballots to cast at Scottish Parliament election. In 2007, we introduced the single transferable vote for elections to local authorities. I think people are becoming used to that and understand that they use the process of ranking candidates. So I suppose what I'm speaking to there is, I think people are well used to becoming acquainted with developments in our electoral system. But I would absolutely concede when it's first introduced, and probably if and when, and again, we all hope it wouldn't be required, but if there is a specific petition, then part of that process has to be making sure that people understand how it works precisely. And by and large, I think rightly, that has to be done by an external agency in the guise of the Electoral Commission, rather than in the hands of Government or Parliament, where it might be perceived not to be as independent as it might otherwise be.
But the Government do recognise that hopefully we will never have this, but when we do, rather than it sitting in a cycle that people get used to, which is, I think, what has happened, because we have seen some challenges with all of the voting systems in Scotland at some stage, there would need to be an education element to it for the voter to understand what they were doing.
Yes.
That's fine. Rona, can I pass it to you?
Good morning, Minister. I wanted to ask you some questions, and we touched briefly on it with previous question from Emma Roddick. It's about the view, it's your view on the physical attendance requirement in the bill for a member to be there if they're absent for 180 days or more. Do you think, I'd like to know the Government's view on that, and also whether you think there should be an actual definitive list of what's, what the criteria should be for that, and would that, some witnesses have suggested it could have a negative impact on diversity for people not being able to attend Parliament. So I just wonder what your views are around that.
I think there's a few issues at play here. I think the first thing I would set out as a general perspective, where it's possible, I think people should be in Parliament. Whether or not that then has to lend itself to being prescriptive and matter which might lead to their disbarment is a wider question. But as a general principle, I think we would all recognise and understand if people don't have a good reason not to be here, and accept that the proposition from Mr Simpson is that if people have a good reason, then they wouldn't fall foul of this requirement. But if people don't have a good reason not to be here, then they should be here on a fairly regular basis. That's just a general observation rather than necessarily a comment on whether or not that should become part of the process by which someone could be disbarred. I suppose it might be felt helpful for there to be a list of acceptable reasons by which a person might be enabled not to be here. I suppose the challenge with that is, and it could be accounted for by saying it's a non-exhaustive list. But the challenge there, of course, is there might be things that we've not foreseen that arise that I think, well, that is a legitimate reason, but we've not prescribed it as one. There could be different means by which we deal with that. The list could be updated, or as I say, you could say it's non-exhaustive. For me, though, the real issues around, and sorry, yes, in terms of the impact, yes, I would concede that it could impact on specific cohorts. I think that's an inevitability. I think, to be fair to Mr Simpson, it's not for me to speak to his bill. I suppose that's why he is suggesting, well, if someone has a good reason not to be here, then that's why they wouldn't be disbarred. But there are some, I think, fundamental questions, because this is predicated specifically on physical attendance, and put inside my personal perspective that yes, people should be here where they can be. We have embedded, and I think it's been a good thing that we've embedded in our system the ability to participate by digital means, remotely from this place, and we don't draw a distinction in terms of a person's ability to participate in proceedings. So if we're not drawing a distinction there, a reasonable question might be, and again, the government doesn't have a perspective on this, so I'm merely suggesting these are questions that need to be considered. But a reasonable question might be, well, why are we now saying that a person has to be here physically within 6 months? So I think that's a question that's open and that needs to be considered. And for me, again, the other fundamental thing that needs to be considered is, who is the gatekeeper here? Who should be the person that determines that's a legitimate reason? So right now, for proxy vote, it's effectively the presiding officer. Who should it be in this instance is another question.
So, I think the fundamental question is what would be a good reason? And the other thing is, local authorities do impose restrictions on, or a penalty in the number of times a member. Now, I'm not sure if that includes remote attendance. Now it does. You're telling me it does? Right, okay, so they've taken that into account.
My understanding is it does, although I think it can differ from local authority to local authority, because they're not prescribed in law. So a lot of these things will come down to each individual local authority's standing orders. But that's a whole other debate.
Yeah.
So.
I mean, I do think it comes down to this question of what do you deem a good reason, and my personal thought is there should be a non-exhaustive list in the bill which would identify things like physical or mental illness, etc., and anything that comes out with that, could be dealt with separately. The other question, which brings me on to, again, something that was touched upon, is the privacy of information at that point about the MSP going out there. And do you think that there's enough in the bill to protect the privacy and confidentiality of information going out about the member, which can obviously be very personal for somebody in public life?
So just picking up, I'll answer that question, but just picking up on your perspective on the notion that there should be a non-existent list on the face of the bill. I mean, that's a legitimate suggestion. I suppose the issue that the slight caution I would have in relation to that is, you know, any legislation has to be interpreted by the courts, and you do start to get into the area of, well, why were those things specifically prescribed and other things not specifically prescribed? So again, that is just a question I think that needs to be considered. In terms of the issues around privacy, that is an area of concern, and I'm not sure there's any way around it. You know, if a person is not here, it becomes recognised that they're not here and they have permission not to be here because they're not then going to fall foul of any requirement. I think inevitably people will either speculate or start to ask questions as to why that might be. And I don't know, you know, if we're going to embed this as part of a process, I don't know if there is a way around that.
You know, other than having a piece in the bill which stipulates no comment to the media about why someone's, you know, not there. It's not for public consumption why they're not there.
Well, sorry, yes. Let me be clearer. I suppose it's perfectly possible to do it within the law.
Yeah.
But when, in terms of practical experience, I think it's inevitable people would speculate.
But there should be an element of sensitivity in the bill, if you like, stipulated around confidentiality. I would imagine that should be something maybe the bill could include.
Well, I think that's a question for Parliament. I guess it goes back to my perspective, which I think most of us would agree with, insofar as it doesn't relate to our public conduct and our work here. People are still entitled to a degree of privacy around their personal lives.
Okay,
the fact that we are public figures and elected representatives, I don't think completely does away with that right.
Yeah. Okay, thank you. So my final question is, it's something, a concern you raised in your memorandum to the committee, and it's around sort of the timing aspect of the appeals process. And the appeals process should be completed before making an MSP subject to recall on the criminal offence ground, which is different to instances where an MSP would be removed because of a custodial sentence of 6 months or more, but less than a year. So I wonder if you could maybe expand on your thoughts around your consideration of that.
Really just draw members' attention to the paragraphs 26 to 28 of the memorandum that we have sent, and it does become a little complicated. You know, there might be a way to deal with it, but effectively, as drafted, the criminal offence ground in section 3 for a recall petition is, as we understand, and no triggered where an MSP receives any sentence of imprisonment or detention for less than 6 months, including suspended sentences, where the MSP is not imprisoned immediately, and of course that might mean they're not imprisoned at all. By contrast, if someone is sentenced for a shorter period than 6 months, they then are open to process of recall. So there seems an inconsistency there.
I think, you know, that's, I don't know if that would...
I think we need to come back to you on that.
Yeah. No, it literally just, I don't think it's referred to, but I mean, obviously that someone can be in remand for a good number of months.
I suppose if you're on remand, my only observation would be you've not been convicted yet.
Yeah, okay. Okay.
But again, it's a question I think that the committee needs to consider, albeit it's for the committee to determine what it wants to consider, but it is an issue that I think is an inconsistency. Now, whether or not it's an inconsistency we say we live with, or it's one that has to be thought through and dealt with, is for Parliament to consider.
And the member and the committee, I guess, as well. Yeah. Thank
you.
Thanks,
everyone. Emma, you had a follow-up?
Yeah, if I can just jump back to the 180 days issue. It is quite a long time, and I'm just struggling to imagine why an able-bodied, mentally well person without caring needs or responsibilities would struggle to do that as a gesture, just to come along one day and swipe their pass at the door. Is there not concern that it's only likely to catch people who do have a genuine reason not to be here, and it's maybe just putting unnecessary light on that?
It's a perfectly legitimate question. I'm not convinced it's one for me to answer. And again, it'll be for the proponent of the bill, for Mr Simpson, to articulate what his rationale is. I would just observe that this is a provision that's in place for councillors. So I presume that is the rationale, but I'm not going to second guess Mr Simpson. I'm sure he'll give you evidence soon to explain why he's determined that is the threshold. My only other observation would be that we are aware, it's not often, but that some councillors have fallen foul of this provision. So it does seem possible, although I would agree it does seem unlikely. And it is a fair question to say, well, it then takes us into the realms of, we are then casting a light on the fact that the only people likely to be not here for that length of time have a good reason not to be, and that then takes us into issues of, well, we're starting to cast a light on that. So I offer no perspective or government position on that, but these are questions I think that the Parliament needs to consider.
I suppose in your role as Minister for Parliamentary Business, you will have some involvement in managing difficult situations and absences amongst colleagues. Do you have any suggestions for how other measures could be considered that might catch those who, genuinely just aren't showing up, but not those who have a genuine need?
You may see a wry smile on the face that our Chief Whip happens to sit in this committee, and I would offer the observation, and she may or may not agree, that I tend to let her get on with that type of issue. No, that's a supercilious answer. So they are issues that we do need to consider, and yes, that would certainly inform our thinking around these matters. They do obviously have to be handled sensitively.
It's not the committee members that are giving evidence today.
Indeed, although it's an interesting concept.
Would the Scottish Government seek, or have they thought about whether or not Scottish Government responsibilities, seems unlikely, but may occasion an absence of that length, should be noted as a reasonable? Because as ministers and cabinet secretaries, you are first and foremost an MSP, and then take on a government role.
I struggle to see the circumstances in which any government responsibility would require an 180-day absence from Parliament. But,
well, let me say a situation where...
It's a good question, and it's not one I've given any thought to.
Right, I'll just leave that there. And the other piece of evidence from the Scottish Government's point of view, the situation with regard to councillors is about the failure to attend a very specific event that tends to be monthly. The bill talks about a period of time here. Are the Scottish Government concerned that there is actually a difference in a fundamental difference in the requirement of a councillor, which is to attend full council meetings, and this, which is just attend physically? I know you've expressed the view about what physical attendance, and we've heard views articulated both within this committee but also in evidence that actually it's really easy just to come and swipe in. But we do not have a registration rule here. You can identify people who have voted. I understand there are often FOI requests as to who was in the chamber. You can always look at the television. Are the government concerned, though, that actually identifying this is a very different circumstance to a council situation, which is a specific meeting that falls at various times with times in between?
I like the idea that it would rely on us watching the television to make sure we have beach towels to make sure we're in the optimal line of sight of the camera, convener. I suppose I would recognise... I mean, this takes us into areas of parity of esteem again and again. It will be for Mr Simpson to answer what the rationale is rather than me. But again, when we talked about the elections bill, I observed that by and large we should have parity of esteem between all different layers of government. So that could be a motivating factor. You steer us in the direction of maybe practical challenges that it would exist. I suppose they would have to be considered if this was to become a prescribed part of our processes. And one other observation, and I think this goes back to the point I made earlier, actually the requirements for councillors might differ from local authority area to local authority area. I've never been a councillor. My understanding in the case of my own local authority area is that the requirement isn't actually full council. If you attend a committee meeting within 6 months, then that fulfils the criteria. So, and they come round with greater regularity than a monthly full meeting of council. So, again, these are all issues that the committee might want to consider.
Thank you. Sue, can I pass over to you?
We have a lot to consider, as I keep saying, and also we really need to consider some of the costs that might be involved in this as well. So I'm going to move to a couple of questions on the financial memorandum. The Scottish Government have said that some of the costs are underestimated. So I was wondering if you can maybe expand on your views regarding that.
Certainly. I think, well, effectively it just comes down to a different assessment in terms of that which Mr Simpson has suggested in his financial memorandum and our
So where's your thinking going with it then?
Well, for example, right now we would consider issues around, have increased costs going forward being factored in. So there's a casting forward of what the cost might be in a specific period. You need to forgive me, I don't have that right in front of me now, but we know that costs will increase as we move forward. I'm not sure that's been adequately reflected in
that's
the
same with every
memorandum.
legislation, I suppose, isn't it? If
Well,
you're thinking about that cost.
That's right, and I'm pretty sure that these are questions that are put to the government on a regular basis about whether or not we've thought about increased costs going forward. So, it's issues around that primarily drive our perspective on the financial memorandum.
You mentioned earlier in one of your responses around the parity element, and you said parity as much as we can achieve. And I suppose there's been a lot of questions and concerns around the costs specifically for the regional recall and poll, and that could be in excess of 2.5 million. So given the concerns you were just outlining there around costs, do you think that's good value for money for the public purse, and what the perception might be out regarding that?
It's a good question. I certainly think the public by and large would expect public resource to be spent primarily on public services, but equally, if there is a public perception that this should become part of our process, then that comes with cost as well. So it's just trying to get the balance right. And these questions of parity of process then do drive certain costs, particularly in the instance of a mechanism which is effectively, how could we best put it, a two-stage mechanism for regions drive increased costs. Whether or not we think that that should become a factor in determining the process is ultimately for Parliament to consider. I think we just need to, the only observation I can offer right now is that a two-stage process is of course going to cost more than a one-stage process.
Okay, that's fine. That's all right then.
No problem. So when we've discussed with previous in previous evidence sessions about where there is a by-election, it falls within the local authority to fund it. Is your view the same for this process? Because obviously, again, a constituency by-election may be arguably can fall within the local authority, but the regional one becomes a much bigger problem. has the government thought about who would take on the financial responsibility for the effectively additional costs that may occur?
I don't want to fall foul of misleading the committee. The committee would not like me to do that. But I think even in the instance of a by-election for a constituency right now, the government bears that cost. I'm looking to my officials to... Ailsa's nodding, so I've remembered that correctly.
Excellent.
So actually, the cost would fall on...
So effectively no additional costs would fall on the local authorities in respect of either a regional situation or indeed a constituency?
Not on a local authority, but still on the public purse.
Of course,
and
on the public,
it would mean that resource would have to be diverted from elsewhere.
Absolutely. One of the challenges, to go back to the very strong advice that we have a agreed battlefield at least 6 months before an election, takes us back to the delegated legislation. We've talked about some of the financial things that need to be looked at. One of the things that's been picked up is the necessity potentially for a criminal consequence if things are mishandled in respect of the petitions or subsequent events. At the minute, the legislation, because we don't have this bill, is silent on that. I think your memorandum suggests that it can be dealt with as these things normally are, in secondary or in other ways. Is the government confident that you can cross those thresholds in time for May next year? That is, identifying criminal responsibility. We've heard about the finance. I'm happy to put that at one side, but the other more practical, should criminal things ever be practical? The other parts that need to be covered in the secondary legislation, is the government confident that it can do that?
Well, I think that actually takes us into a wider question around the timescale, because the bill prescribes that everything should be in place within 6 months of royal assent. And candidly, no, I am not confident. Now, if you were to ask me that, if this was this had been legislated for 2 years ago, I'd probably say, yeah, we probably could do that within 6 months. I should caveat this with a reassurance that I see nothing in the parliamentary timetable or the timescale we have that means we can't pass this bill before the end of the session. But if we are required to implement it all within 6 months, that's going to be pretty exacting. That's going to be pretty challenging, because we go into dissolution in March. We then have a period after the election where it can take about a month before committees are up and running. I would imagine, I would expect, I'd be surprised if it wasn't the case, that the relevant committee of Parliament, probably most likely the successor to this committee, would want to take evidence from the government in terms of what it's planning on doing, just as we're about to do in relation to another act of Parliament. So I think it's actually a wider question about the timescale for implementation. Right now, I think it would be very difficult to do it, and to do it with justice in the timescale prescribed.
The Minister has raised the question of the commencement date. What is the Scottish Government's proposal with regard to that? Because obviously what we're now looking at is not having legislation in place for the Holyrood election next May, which means that we will have an unknown field in relation to a very small element of electoral. Let's be honest about that, and hopefully one that certainly will not be tested for as long as possible. What's the government's view on the time period it would need to ensure that it can facilitate that secondary legislation?
I can't give a specific answer to that. I mean, I know there's quite often cynicism about this, but the preference is not to have a prescribed period after royal assent for things to be put in place, just to take account of eventualities. Once Parliament has legislated for something, the expectation is we get on with and implement it as soon as possible. So that would be government's commitment to Parliament.
Okay. Loath to push you further than that. Graham, time's ever so slightly tight, my apologies, but is there anything that you would like to pick up with the Minister before I finish this part of the evidence session.
Thanks, Convener. Can I thank the committee again, as I always have, for the breadth and detail of their questions. I think it's been an excellent session. And also thank the Minister for the way in which he's worked with me so far, and I think that will continue. If I could just press the Minister on the recall question, because there have been questions raised with the committee about the two-stage process that I'm suggesting, and some people have suggested that maybe there should just be a one-stage process. Does the Minister have any view on that?
Well, first of all, just to give Mr Simpson a reassurance, we'll absolutely continue to engage with him on this bill. I think he knows that we had very good engagement in the elections bill, and I can certainly assure him that my commitment is to continue doing that on this legislation. I mean, in terms of do we have a view, no, we do not. But you know, we've obviously, well, we didn't actually, from recollection. I've got a memorandum in front of me. I'm not going to. You need to wait for a while for me to read it through in detail. But I don't think we particularly posed this as a question beyond the cost implication. But it's a question. I think it's an open question that the committee and Parliament need to grapple with. We don't have a specific view on the merits or otherwise of whether it's a one-stage or a two-stage process.
Okay. And just on the bill in general, are there any red flags in the bill for you?
I'm loath to describe it as a red flag, but I would go back to the point I've just made about a realistic timescale for implementation.
Yes. And just to put on the record, we have discussed that. You and I have discussed that. And I'd agree with the point that you've made. And I think there's... well, let me pose it as a question, so I'm not making a point. Would you agree that this is something that could be explored at stage 2? Should the bill get to stage 2?
Yes, I think we'd have to. You know, that would take us into territory of, as much as I'm saying this is for Parliament, you know, that would be where I'd probably, you know, if no one else does, I'd probably be seeking to bring forward an amendment. But I'll obviously work with you, Mr Simpson, on that.
And finally, just to put on the record that in terms of amendments, and I'm not getting ahead of myself here, but I've been in constant discussion with the Electoral Commission, who have already suggested a number of amendments. If I can put it as a question again, do you see that there's an opportunity here to actually have the, if this does proceed, to have the best system of recall in the UK, and we can actually improve on what exists elsewhere?
I think that's what we should aim for. So I suppose my response to that would be we shouldn't seek to, by necessity, replicate what's in place at Westminster. We should create a system that we think is proportionate and we think it works for us as an institution and fundamentally which works for the public here in Scotland.
Okay. Thank you, Convener.
On that very positive last comment, can I thank the witnesses for their evidence, and particularly the Minister. I understand the Minister is staying with us for another exciting session, but I will suspend so we can have a changeover in officials. Can I welcome everyone back to item 3 on our agenda, which is to take evidence from the Minister and officials on the issue of dual mandates, though it may turn out to be more of a discussion than a traditional evidence-based format. We will see. Members have been provided with the information about the consultation undertaken by the Scottish Government, for which I thank the Minister. And I would note that the expectation is that subordinate legislation in relation to dual mandates will be laid and referred to the committee in the future. So discussions today do not preempt our scrutiny, both formal and otherwise, of these future regulations. So can I continue to welcome the Minister for Parliamentary Business and his supporting officials, who for this session are Ian Hockenhull, who's Elections Bill Team Leader, Ilse Kemp, stays on as Parliament Legislation Unit Team Leader, and Jordan McGorry as Solicitor. Minister, would you like to make some opening remarks and take us through your consultation?
Certainly, I feel very welcome, so that's nice. I wouldn't say too much by way of opening remark. I would certainly hope that it is a discussion format, because I'm as interested. I will, of course, answer any questions posed to me, convener, but I'm interested to hear what the committee thinks in relation to what the regulations might look like. A reminder, convener, that the Act that was passed requires government to bring forward regulations in relation to dual mandates for MPs and for peers. It didn't prescribe a specific timescale, but I did make a commitment to bring them forward in time for Parliament to consider in advance of the 2026 election. I restate that commitment. We will be able to meet that requirement. The bill also enabled us to bring forward regulations for councillors in relation to dual mandates, but did not require us to do so. So we're giving that some consideration as well. Not only am I committed to bringing them forward in time for Parliament to consider, I'm also committed to doing it in line with the Gould principle. So on that basis, I've envisaged laying regulations in September to ensure that Parliament has the chance to approve them by November. Of course, it's in the hands of Parliament and for Parliament to consider, just by way of background. And I think I expressed this as my broad concern about these issues being put in the face of the elections bill as was then. My concern being that we hadn't had the chance to consult on these matters properly. I was very grateful to Mr Simpson, who I see has remained with us, convener, for the ability to work with him to come up with a solution, which was the ability to make these things by regulation, to enable us to consult. So we have had that consultation. We ran a public consultation on the issue on the 20th, starting on the 20th January. It ran for 9 weeks. We had 77 responses, and subsequent to that consultation, I've held 2 roundtables. The first with representatives of 4 of the 6 parties represented in Parliament. All 6 were invited, I should say. 4 accepted the invitation, and another round table with a range of other stakeholders who have an interest in these matters as well. They were very useful and instructive in informing my thinking thus far. I should say my thinking is not completely finalised, but it would be disingenuous to say it is not further advanced than it was at the outset of the process. I'll be very happy to explore that further with the committee, but very keen to hear what the committee might think as well.
I'm very grateful, Minister, and I continue to welcome Graham Simpson, MSP in Relations, interested in this matter, and at the appropriate time, Graham, if you have any questions, I'm more than happy to bring you in. If I can just kick off then, Minister, 77 responses. I'm not going to go into the split between individuals and groups that responded to, because I don't think they've been published yet. So we have the headline figures. Satisfied with the level of response?
I mean, I always would have, it'd been nice if there was more, but...
Well, let me ask it different. Are you satisfied with the range of responses that you got? Does that allow you to take your thinking forward, confident that there is a view out there?
Yes, I think it does. I suppose the first observation I would make, at least and I've made this point, in relation to MPs and peers were required to do this, but the response we've had have been useful. The discussion I had in particular with both political parties, and especially the discussion I had with the second round table, which included the Electoral Management Board, which included a clerk from the House of Lords, included the Electoral Commission, included a representative from IPSA, who we know manage the allowances system for the House of Commons. That was very useful indeed in terms of informing my thinking on a practical basis. So, yes, I think it has been a helpful process.
Mm-hmm. And certainly when we look at the top level question about whether or not a dual mandate should be held, there was substantial response to say no, both MP, MSP counts and so. Although the top level responses were interesting with regard to the House of Lords, where rather than a grace period, there was effectively the opportunity to have a leave of absence. What's your view on the responses that you had, which, you know, were yes, there should be a leave of absence was 21, no 48. What did you?
Well, it's well, all I can draw the conclusion is that those who have an opinion largely fall into the perspective of saying that a leave of absence doesn't fulfil the requirement of ending a dual mandate. Now, the manner in which we've drafted the regulations enables us to legislate for that to meet the threshold, but it doesn't require that to be the threshold. So that's something I'm grappling with just now, and again, I'm more than happy to hear the committee's perspective on it. I've got.
Do you want to tell us where, as you grapple it, where you're inclining towards in respect of that? Well, is it following this view here, or is it, you know, following?
So it's just about to make that the point, Kevin. You know, I have, and, you know, it's no matter of secret. My party has, and I have a particular perspective in relation to the House of Lords. But I'm also conscious that, you know, there'll be a range of views in Parliament. I'm also conscious we have had the experience of those who have served in the House of Lords and been a member of Scottish Parliament. We have one such member just now who operated a self-denying ordinance and took the leave of absence. So, you know, that demonstrates it's possible. Whether or not that meets the requirement in terms of public expectation, albeit I completely concede it's you know, it was, yes, 77 responses were very helpful in informing our perspective, but, you know, it's not a huge upsurge of people responding to the consultation. But for those who did, you know, that would suggest that actually they don't think that fulfills the requirement. So I'm still considering it, and it's actually one of the things I'd be very happy to hear from the committee, you know, notwithstanding the point, and I understand why you qualified it, that you've still got the scrutiny role, but the perspective of the committee would be helpful.
I'm content because I know the actual specifics have not yet been published, but do you think that this committee will get more insight once we actually see responses? Did it extend beyond in the commentary elements of it that might help us to understand why it came out the way it did?
I think so, but, you know, it's in the eye of the beholder.
No, absolutely, absolutely. And the other point I was going to invite you on, because obviously one of the most challenging elements of this, as you've already mentioned, is the grace periods. And I think people come to this with a different view, either depending on their experience, depending on their oversight and knowledge of it. Are you starting to develop is the Scottish Government, starting to develop a view on what the appropriate grace period should be? And maybe they would be different depending on the dual mandate element?
So, yes, I'm happy to speak to that, where my thinking broadly is just now. Not necessarily finalised, and again, happy to hear what people think in relation to that. Absolutely doesn't have to be, and I think And again, I'm happy to speak to where we might end up with bringing forward regulations for councillors. I don't think it should be the same grace period for each cohort. I know that Mr Simpson, when he brought this forward, proffered, I think, the period of 8 days for MPs and peers. I think it's possible, having spoken with IPSA, it's possible we could work a system like that. I'm beginning to think in relation to MPs it would be preferable to have a slightly longer period, maybe tied to that period between the election and the summer recess, largely just for practical matters of an MP being able to wind up their office and do that in an orderly fashion. IPSA informed me, that is kind of built into their system already, but notwithstanding that, and of course we can't legislate for that. That could change. So we have absolutely no ability to legislate for what IPSA might put in place or what rules might be for the House of Commons. So going back to the point I made earlier about future-proofing systems, I think it would be sensible for us to have a short period, but probably a little longer than 8 days. So,
and can I just intervene? And can I ask, is the Scottish Government settled on a view it needs to be post the election rather than pre the Scottish election? So an MP wouldn't be required to step down prior to the election. It would be as a consequence of the result of the election.
We're not, even if we had that perspective, convener, the way our regulations are devised, we could not compel anyone to stand down. So we can only deal with.
You could prevent them being returned.
We can only, yes, we can only deal with this after a person is elected. So that's where our regulations
cross here.
No, not at all. So that's where the thinking is for MPs. For peers, I don't think our process requires it to be that long, so that could lead you to a place where it could be done much more quickly, maybe more in line with the 8-day period, because clearly they don't have, certainly they don't have publicly funded offices in the same fashion that MPs do. That's balanced against the, would it be more straightforward and ready to understand for the public out there that there's equivalence for peers and MPs. I've got an absolute fixed viewpoint in that. But again, certainly, I don't think it would be a long period. So, I certainly wouldn't be suggesting anything further or longer than we would have for MPs. If anything, we could do something shorter, but it might be that we conclude it's just the most straightforward thing to do is just to make it the same period for a person to consider their position in respect of being an MP or being a peer. For councillors, well, let me start off by saying I'm increasingly being drawn to the fact, despite us not being required to, probably will bring forward regulations for Parliament at least to consider. I think Parliament should have the ability to consider it. I was particularly struck by the comment of one participant in the second roundtable I had, and it actually speaks to the wider issues that we've touched on already, which we touched on in the bill, around parity of esteem. So if we're suggesting that if you're an MP or a peer, you shouldn't have a dual mandate, well, in terms of parity of esteem, the same should be true of councillors. And I think that's a fairly persuasive argument, or at least enough for me to bring forward regulations for Parliament to consider. That said, there are practical issues around that, and we know that the most significant cohort of people who have been elected with a dual mandate have, in our experience thus far, not been MPs, not been peers of the realm, it's been councillors. And there is also a practical issue around, do we want to force a raft of by-elections in what would be a fairly short period between one fixed election and another fixed election. So we know in Wales that they it prescribed, when they took this forward, they prescribed a period of, I think, if I remember correctly, 372 days to account for the fact that they'd have a local authority election scheduled not long after an Assembly or a Senate election, I should say, although they've actually moved away from that. I'm not quite sure their rationale for moving away from that, but certainly that was their initial rationale. I'm probably drawn towards that being sensible, with the exception, and we do have the ability to vary it contingent on when a person's elected. So if someone's a councillor elected at a by-election, I don't think it would be sensible then to say, well, it should be a year, so we could maybe tie it again more to the period that there is for an MP, and potentially, depending on where we land, with a peer.
And your thinking in relation to the grace periods for, in essence, all of these situations is predominantly around the Holyrood election, the council election. Are you confident that the timings that you may get to will also support in a by-election situation, which could also occur where you end up with a dual mandate because of a by-election in this place?
Yes, so I suppose that was the point I was making, Convener. If we were to prescribe, if we were to bring forward regulations, as I'm giving fair indication, I think, to the committee, I am likely to for councillors, I think we would have different trigger points. If someone's elected at the general election, and we know that there's an election coming up within a year, don't require them to stand down until the next series of ordinary council elections. If someone is elected with that period, I don't think we'd have a year's grace period. We'd need to have something rather shorter. And for consistency's sake, it would probably be something, I think, akin to that for MPs.
That's helpful. Sue, did you want to come in? My apologies.
I'm not sure if I do. I'm struggling because when I say I'm struggling,
Explore it. This is a different sort of evidence.
the grace periods. So a councillor then is elected as an MSP. Are you, because all of the evidence that we've had has come in stating that there would be that grace period to allow them to carry on in that role for a period of a year,
Yep.
give or take. And that's something that I would certainly personally support. And I'm just clarifying that that's where your head is going as well.
Well, I don't know if I'd like to tell you where my head's going
Well,
on a
well,
regular basis, but yes, that is, in
that
this
is-
instance, I'm happy to say that is where my head is going.
Yeah, because
Except for the point I would make.
yeah, that's what I'm trying to explore. Where's your exception? So
My exception would be if, let's say, someone is elected as a councillor
and then becomes an MP,
and becomes an MSP
an MSP.
subsequent to the next round of ordinary council elections, then I don't think it would be sensible to say they have to wait a year.
Oh, so you mean that if there's a by-election or
Correct.
some other reason that person then
Correct.
becomes an MSP, and that I understand now where you're going, and I accept that. Thank you. I was confused.
No problem.
Clarification, nothing wrong with that. Rona, did you want to?
Yeah, thanks, convener. Yeah, I wanted to ask you about salary limitations because I think this is a key element of this, certainly in the minds of the public. You know, it's their money that we're spending. So most respondents have stated that in the case of MSP, MP dual mandates, the elected representative should only be allowed to receive a single salary. And some have suggested the retention of the higher of the two salaries, and have suggested it should be the original salary that ceased upon election to the Scottish Parliament. Is the government forming an opinion on that, about whether, you know, keep it simple, as soon as you are elected to a different institution, that previous salary stops?
So we can't do that.
You can't do that.
So we cannot prescribe the rules for MP salaries. So I understand why there's been a response from the public. Oh, well, you now should be only entitled to draw the MSP salary. We can't do that. What we could do, and what we are exploring, is whether or not for that, and it would be a very short period, of course. Let's remind ourselves that until you've given indication you're standing down as MP, you're not entitled to draw down your MSP salary. That's something we could do. In the instance of councillors, we could, because right now a person, if they're an MP, is only entitled to a proportion of their MSP salary. So if someone's a councillor, we could prescribe, for example, they're only entitled to a proportion on their MSP salary, taking account of their councillor salary. So these are things that we're grappling with. But we need to be clear, and I think it's important we're clear with the public, that the only thing we can legislate for are the issues around pay, salary, entitlement, privileges, rights in this place. We cannot determine them for other places. So if you take another example, and I know that, and again, I understand why people were making the point around there should be a limitation on the rights of peers and MPs in terms of their participation in the Lords of the Commons. We can't prescribe that. It's not within our gift. So we also need to make sure that everyone understands that too.
Useful explanation. I didn't actually realise that, so thank you. Thank you.
I suppose, well, the next natural part to go with that is really in relation to the rights and the privileges that fall during that grace period. Do you want to explain where the Scottish Government's thinking is on that, again, being unable to affect institutions outside of Scotland? What is your view about, you know, in effect, the rights and the privileges of being an MSP? Should we curtail it? Should we not?
I think by and large the answer is no, for practical reasons. Now that, you know, the exception there might be certain allowances in terms of setting up an office and so far, although I've not drawn a specific conclusion. That could be more hassle than it's worth, although that's balanced against the fact if a person decides not to quit as an MP, then, you know, why are we letting them set up an office for a few weeks? So, you know, that's something we grapple with. I think the more fundamental questions have been around their ability to participate in parliamentary proceedings. I do not think we should limit that for the very practical reasons of that would impact the selection of Parliament's nominee for First Minister. It would impact the Parliament's ability, or parliamentarians' ability to determine who the presiding officer, deputy presiding officers. It might be to impact on parliamentarians' ability to determine who should go forward to hold office, who hold ministerial office. So, and that then takes us into real questions around, you know, the public have elected Parliament on a specific, proportionate basis, and these things should be reflected on that basis. So, I think it would add a level of complication that I don't think would be helpful.
Is it also the case, though, that in essence, when the discussion is occasioning about the salary, that is in essence an individual MSP, you know, the reward for doing it, whereas actually the rights and privileges are there so that they can represent the constituents who by choice have sent them there. And to allow that level of versatility allows the Parliament to develop while urging an individual to do the right thing.
Precisely. I think that's an erudite explanation of what I was trying to say, Convener. So I'm going to remember what you've said and we'll use that next time.
Emma, I think you would like to come in.
Kind of sidestepping along there, what about the holding of ministerial positions? Is there a view that while an MP, they should not be able to hold ministerial office until that is settled?
We've not considered that. Again, that would add in another layer of complication. I think these are things that we would be guided by practical considerations. I mean, I think realistically, whilst we'd have a prescribed period in which a person must do it, I'd be surprised. Certainly in such circumstances, a person might be appointed to ministerial office. They don't give a very early indication that they intend to leave the other institution.
But that intention to leave is enough, not that they've already left?
I think so. It would add another layer of complication and complexity.
Okay.
I mean, ultimately, if they didn't exercise well, they would be required to exercise it. If they didn't, then they would cease to be an MSP and they could no longer be a minister. Because to be a minister in the Scottish Government, you have to be an MSP.
Official.
Well, it's exceptional law officials. Let's not overly complicate this.
Oh, there's an interesting dual mandate we could go into.
Let's not overly complicate this, Convener.
Okay. Graham, is there anything that, as an MSP, you would like to ask the Minister or contribute?
Yeah, given it's a discussion, I'm just reflecting on what's been said. I think one of the key issues is the grace period. If somebody is elected here while being an MP, and I proposed 8 days because that exists in Wales. That's their limit. So I thought we should have some consistency there. And the minister is saying he's minded not to go with 8 days, but to go with, well, let's have it after the summer recess. I just wonder. Yes, of course, it's a discussion.
Just to clarify, it wouldn't be after the summer recess. It would be up to the point of the summer recess. So we're really talking about a 6-week period or something.
Okay, right. Well, that's useful then. So I just wonder whether it's worth actually just saying 6 weeks, because we'll have a situation where there will be by-elections where the summer recess doesn't come into it. So is it better to just prescribe 6 weeks rather than 8 days?
So forgive me if I wasn't clear. Yes, we would prescribe the time period. I was merely making the point that the time period would probably reflect that would be our usual period running into the summer recess. So we wouldn't prescribe it up until the summer recess. It would be however many weeks.
Okay, that's really useful. The other situation that could arise and has arisen is if somebody is an MSP and becomes an MP and therefore has a dual mandate. I wonder if you've considered what happens in that situation.
The precise same thing would happen. They would then have to...
They have to make a choice.
Make a choice within the prescribed period.
Basically. So your regulations will set that out. If you're an MSP, become an MP, you have to choose. So it's one or the other.
To put it in really simple terms, what it will do is prescribe a time period.
Right. Okay.
And it doesn't matter which came first.
Okay.
So the dual mandate.
Yes.
Because of the time period rather than how it came about.
Correct.
Yeah. Okay. And on the question of the House of Lords, because this isn't an easy one. It's an easy one if you're against the House of Lords, but if you're not against the House of Lords, if you think the House of Lords should exist, then it's the question of should you allow this leave of absence, which, as you rightly say, one current member of the Scottish Parliament does enjoy that at the moment. Where actually are you on that? I mean, do you think the leave of absence should exist or not?
I'll be perfectly candid. I'm grappling with my own personal perspective and what I think Parliament might expect. So that's where I am just now. There is a complicating factor in that, and there's been, and again, this is why the session, and I would commend to the committee where we get to the stage. It's not for me to say who the committee should take evidence from, but I found it very useful taking evidence from the people I've mentioned. I'm sure the committee would as well. But the clerk from the House of Commons, from the House of Lords, said that their processes have changed. So a leave of absence, it used to be from parliamentary session to parliamentary session. They've now got to do it each and every year. That becomes another complicating factor for us. Who's checking that here? So that's something else we need to consider.
Yeah.
And the other factor as well, as much as I'm grappling with my own perspective, those who respond to consultation far more said that it should be actual resignation from the Lords rather than leave of absence.
Yeah. Okay.
Thank you, Graham.
Okay.
I think what has come up, and again, can I thank the government for sharing the information and the evidence that we've heard today. I think what has come through, both in the evidence that the government has taken, but also subjectively what a lot of people view is that these roles are full-time roles and there is an expectation that they're fulfilled in that way. So the reason to address dual mandate, I think, is both pertinent and even though maybe the minutiae it isn't available to some people, that principle that an elected role or otherwise is a full-time job and needs to be treated that way is a useful one to keep in mind when we're talking about these. Unless the Minister has anything else that you want to offer, can I thank you for both your evidence sessions today? Can I thank those that support you? And I will now move this session into private, and we will meet again in public not before 1 p.m. today. Thank you, Minister.